Hi, this is patent attorney Steve Aycock. In this video, I'll be answering the question of patent versus trademark and which one is right for you. Before we dive in, please be sure to subscribe and hit the notification button so you'll get notified when we add new videos about protecting your ideas. A patent gives the owner the right to exclude others from making, using, or selling an invention. There are two main types of patents. The first is a utility patent that covers mechanical devices, processes, software, and chemicals. And the second is a design patent, and it covers the ornamental appearance of an object. So if your idea falls into one of the categories of a device, process, software, or chemical, then a utility patent might be the right way to protect it. If it is based strictly on appearance or includes appearance as an aspect, then a design patent might also be a way to protect your idea. Design patents and utility patents can be used together to protect an invention. Trademarks, on the other hand, are used to protect the branding of a company, and they can be used to protect the brand name, logos, and other things such as the appearance of products, the colors, or sounds. Um, Trademarks are things we think of as the Nike symbol, the Coca-Cola logo, and car emblems such as Mercedes. Those are some examples of trademarks that are known all around the world. But those tell you that that product came from that company. And so they are used to protect the branding of uh, the products or services. And I'm going to talk about three scenarios next to give you an idea about the patent versus trademark question. And in the first scenario, this is where you would use patent only and not trademark. So in this case, in the patent versus trademark, it would be patent. And this is when you have an invention, such as a physical product, a mobile app, software, etc., but you do not have any branding for it yet. And so in this scenario, you would want to use the patent only because you don't have the branding yet for a trademark. In scenario number two, this is trademark only and no patent. This is when you have branding, but you don't really have a invention, a product invention. So this may be when you're going to be selling products from other manufacturers, but you want to do some unique branding. That's kind of your main business idea. So let's say you are reselling products on Amazon, but you wanted to have them labeled with your own branding. This is when you'd be protecting the branding of the product, but not the invention because you didn't invent it. It's products that were already there. And the third scenario is when you would use patent and trademark. So this is when you have invented something and you have the branding that you've created as well. So for example, you may have a mobile app idea, you have the branding for that, or a physical product, and you have some branding you want to go along with it, like a company name, or a product name, a category name for your company, logo, things like this. And you'd want to put those on your, protect those with your trademark, and then the invention part you would protect with the patent. Now, you do have to keep in mind that this isn't a one-time answer. The patent versus trademark question and about which one is correct for you isn't a one-time thing because things change. So, for example, you could come up with a product idea for your brand. Maybe you started out selling other people's products under your brand name, but found that customers wanted certain features, and maybe you come up with a new product then that you're going to add to your brand, and maybe instead of just trademark, you now are going to add patent to protect your new product idea. On the other hand, maybe you have a product that you've invented and never had branding for it, and then you come up with brand ideas for it that you want to protect with trademark. So keep in mind that um, the question of patent versus trademark isn't a static question. It's a question that you address at every moment things are changing, or as things develop. It's a question you keep revisiting to say, okay, am I needing patent or am I needing trademark at this particular point in time? If you want to learn more about protecting your ideas, including how to do DIY patents, trademarks, and copyrights, please see the description for a link to Invention Shield. That is the place where I have courses that I've created that take you step by step through protecting your ideas. We will be enrolling in the courses soon here. They'll be opening up for enrollment. So if you'd like to go there now and sign up for that, and we'd be happy to notify you when enrollment opens for the courses there. And thanks again for watching. I hope this video was helpful to you. If there are other topics or other questions you have, please feel free to leave those in the comments. I'd be happy to create other videos or address those questions in upcoming videos about patent, trademark, copyright, or other intellectual property. Also, too, please be sure to subscribe and hit the notification and like buttons if you enjoyed the video. Thanks again. Good luck with your ideas.